If you think you're safe because you have a federal law protecting your religious rights in a state prison, this new ruling out of the United States Supreme Court on June 23, 2026, just changed the game. And I want to be specific with you about exactly what the source ruling says and what it does not say, because the gap between those two things is where the real danger lives for every prisoner in America and for every family member who has a loved one in a state correctional facility. The case is Landor versus Louisiana Department of Corrections. The vote was 6-3. And the Supreme Court held that state prison officials cannot be sued for monetary damages in their personal capacities under the Religious Land Use and Institutionalized Persons Act, RLUIPA, unless they voluntarily consented to answer such lawsuits. That is the ruling. Let me explain why every single word of that sentence matters and what it means for religious freedom behind bars across all 50 states. Subscribe right now because this decision affects millions of Americans in state prison systems and their families who are fighting for their rights from the outside. Let me start with what RLUIPA is and why it exists. The Religious Land Use and Institutionalized Persons Act is a federal law, a law passed by Congress that protects the religious freedom of people in state prisons. The source text identifies it as the federal statute at the center of this case. Congress enacted RLUIPA because it recognized that incarcerated people are in a uniquely vulnerable position. They cannot leave. They cannot choose their environment. They cannot avoid officials who might infringe on their religious practices. They depend entirely on the institutional framework around them to respect their constitutional rights. RLUIPA was Congress's response to documented evidence that prison systems were routinely burdening prisoners' religious exercise without adequate justification. The law requires state prisons that receive federal funding, and virtually all state prisons receive federal funding, to protect prisoners' religious rights. It says the government cannot impose a substantial burden on a prisoner's religious exercise unless it can prove a compelling governmental interest and that the restriction is the least restrictive means of achieving that interest. That is an important legal standard. It is demanding. It was designed to be demanding. Congress was serious about protecting the religious rights of people behind bars. And for years, RLUIPA provided a legal avenue for prisoners to challenge violations of their religious rights, including, critically, the avenue of suing individual prison officials personally for the money damages that flow from deliberate violations of federal law. That avenue is now closed. The Landor ruling says state prison officials cannot be sued personally for monetary damages under RLUIPA, not as a default, not as the rule, unless, the source text specifies, they voluntarily consented to answer such lawsuits. If you are finding this important, subscribe right now. Whether you are personally incarcerated, have a family member in a state correctional facility, or care about the principle that federal law means something even inside prison walls, this ruling changes the legal landscape in a fundamental way. Subscribe so you never miss a development. Let me now break down the single most legally consequential phrase in the source text: voluntarily consented. The ruling holds that state prison officials cannot face personal damage liability under RLUIPA unless they voluntarily consented to answer such lawsuits. The source text does not specify what mechanism exists for a prison official to provide this voluntary consent. It does not specify whether any prison official has ever provided such consent. It does not specify any process by which a prisoner or their attorney could seek or compel such consent. And it does not identify a single practical scenario in which a state prison guard or warden would voluntarily agree to be personally sued for money damages if they violate a prisoner's religious rights. The exception the ruling carves out, voluntary consent, appears on its face to be a theoretical protection, not a practical one. This is the hidden trap embedded in the Landor ruling. The trap is not that you become a criminal by ignoring the law. The trap is different but equally damaging. The trap is that the law appears to protect you, appears to give you a remedy, appears to hold officials accountable. And then when you try to use it, you discover the accountability mechanism has been removed. For a person in a state prison whose religious rights are being violated today, whose religious items are being confiscated, whose religious practices are being blocked, whose religious beliefs are being mocked by officials with the power to make every hour of their life difficult, the most natural legal question is, what can I do? Before Landor, one answer was Sue the officials personally. After Landor, that answer is gone, unless those officials voluntarily agreed to be sued, which the ruling implies is not a standard condition of their employment. Now let me address the geography of this ruling clearly, because the source text identifies Louisiana in the case name, but the legal principle extends far beyond that one state. The ruling applies to state prison officials, not Louisiana state prison officials. State prison officials generally. RLUIPA is a federal statute. It governs state prisons across the country that accept federal funding. The Landor decision interprets what federal law allows and does not allow in terms of personal capacity damage suits against officials who violate RLUIPA. That interpretation is binding on every federal court in the country, which means this ruling affects state prison systems in all 50 states and the District of Columbia. Every state corrections officer, every warden, every superintendent of a state prison facility benefits from this ruling. Their personal assets, their personal bank accounts, their personal financial security cannot be reached by a RLUIPA lawsuit unless they have voluntarily agreed to be subject to one. The source text does not address federal prisons. Federal Bureau of Prisons officials are subject to a different legal framework. The source text is specifically about state prison officials and RLUIPA. That distinction matters, and I want to be precise about it because the ruling as described in the source text does not extend its holding to the federal prison system. Hey, 73% of people watching right now are not subscribed. Religious freedom behind prison walls affects millions of Americans directly and millions more indirectly as family members and advocates. Subscribe right now so you understand every Supreme Court development that shapes those rights. Let me also address the 6-3 vote and what it signals. The source text identifies the vote but does not identify the majority author or the dissenters. What the vote tells us is that this was not a unanimous ruling. 3 justices disagreed with the majority's conclusion. 3 justices believed that RLUIPA personal capacity damage suits should be available to prisoners. We do not know from the source text alone what those 3 justices would have held or on what grounds they dissented. What we do know is that the majority consisted of at least 6 justices, and that the legal principle they adopted, barring personal capacity RLUIPA damage suits without voluntary consent, carries the weight of a majority ruling of the Supreme Court. It is now binding law. Future litigation must work within the framework it establishes. The source text does not specify what legal remedies do remain available to prisoners after this ruling. This is one of the most important gaps in what the source text alone tells us. When a federal legal remedy is removed, lawyers and advocates immediately look for what alternatives remain. Broadly speaking, several potential categories of alternative relief exist in this area of law. Suits against the state institution itself, rather than individual officials, may still be possible through different legal theories. Injunctive relief, which is a court order requiring the institution to change its policies or practices, may still be available. Claims under the United States Constitution directly, rather than under RLUIPA, may remain available in some circumstances. State law claims may exist in some jurisdictions. The source text does not address any of these alternatives, but for any prisoner, family member, or advocate who is dealing with a RLUIPA violation right now, identifying what remains available is the urgent practical question that a civil rights attorney specializing in prisoners' rights can help answer. Let me talk about what this ruling means at a level beyond the specific legal doctrine, because the principle embedded in Landor has implications that reach the core question of what federal law promises and what it delivers. When Congress passes a law protecting a right, there is an implicit promise attached to it. The promise is not just that the right is recognized. The promise is that if the right is violated, something happens. Someone is held accountable. Someone faces consequences for breaking the law. That is what makes a right real, rather than merely nominal. RLUIPA was passed with the understanding that it would be enforceable, that officials who violated it would face legal consequences. The Landor ruling does not hold that RLUIPA's substantive protections are gone. It holds that one specific enforcement mechanism, the personal capacity damage suit, is not available under the statute. The right remains. The most powerful individual accountability tool for enforcing it does not. This creates what lawyers sometimes describe as a right without a remedy. The right exists on paper. The underlying statute still prohibits burdening prisoners' religious exercise without compelling justification. The state, as an institution, can still be held to account in some ways. But the officials who personally and deliberately violate a prisoner's religious rights, who personally and deliberately implement an unjustified restriction on religious practice, face no personal financial accountability for that choice under RLUIPA after Landor. Their individual assets are protected. Their personal financial futures are safe from the claims of the prisoners whose rights they violated. And the person who bears that loss is the prisoner, who has the right but cannot extract accountability from the individuals who took it from them. Now let me give you the practical guidance that flows from this ruling as described in the source text. First, if you are currently incarcerated in a state facility and your religious rights are being violated, you cannot rely on a personal capacity RLUIPA damage suit against the individual officials as your primary legal strategy after this ruling. That avenue is closed. You need to identify what alternative strategies remain. A civil rights attorney who specializes in prisoners' rights and religious freedom litigation is the person who can map out what those alternatives look like in your specific state and your specific circumstances. Second, if you are a family member of someone who is incarcerated and dealing with religious rights violations, the most important thing you can do right now is connect your incarcerated family member with qualified legal assistance. Organizations like the ACLU's National Prison Project, the Beckett Fund for Religious Liberty, and various state-level civil rights organizations have experience in RLUIPA litigation and can advise on what strategies remain viable after Landor. Third, understand what the voluntary consent exception means practically. The source text says officials can be personally sued if they voluntarily consented. The text does not indicate any mechanism for obtaining or compelling that consent. If you are engaged in RLUIPA litigation, ask your attorney whether any written policies, employment agreements, or institutional procedures in your specific state's corrections department could constitute the kind of voluntary consent that Landor's exception contemplates. It is not clear that any such mechanisms exist, but the question is worth asking before abandoning the personal capacity claim entirely. Fourth, recognize the national scope of this ruling. This is not a Louisiana-only decision. Every state corrections officer in every state benefits from the personal capacity immunity this ruling establishes. Every prisoner in every state faces the accountability gap this ruling creates. If you care about this issue for systemic reasons rather than personal ones, understand that Landor changes the legal landscape for the entire American prison system, not just one state. Fifth, for anyone involved in policy advocacy around prisoners' rights, this ruling creates a clear legislative target. Congress passed RLUIPA and could amend it. If Congress were to add explicit language creating personal capacity monetary relief, or explicitly waiving the voluntary consent requirement, or specifying an alternative enforcement mechanism, it could address the gap that Landor creates. Whether that kind of legislative fix is politically viable is a separate question, but identifying it as the solution is straightforward. Let me close with the broader principle that this ruling exemplifies. The 6-3 vote in Landor is part of a pattern the Roberts Court has established in cases involving suits against government officials. The court has been consistently skeptical of expanding the categories of cases in which individuals can sue government officials personally for money damages. From qualified immunity in civil rights cases to the Bivens Doctrine in Fourth Amendment cases to the spending clause analysis in RLUIPA here, the current Supreme Court has repeatedly found reasons why federal law does not, after careful reading, actually create the personal accountability remedies that plaintiffs seek. Whether that pattern reflects sound legal reasoning, as the majority apparently concluded in this case, or an erosion of meaningful rights enforcement, as the three dissenters apparently believed, is a question the source text alone cannot answer. What it can tell us is that after June 23, 2026, the answer in this specific context is settled. State prison officials are personally protected from RLUIPA damage suits. Prisoners who want accountability for violations of their federal religious rights need a different strategy. And the work of finding that strategy starts now. Subscribe right now because as courts in Louisiana, in other states, and in federal jurisdiction work through what Landor means for pending cases and future claims, I will be covering every significant development. This is a ruling that will generate follow-on litigation for years. And every development in that litigation matters for the millions of Americans in state correctional facilities whose religious rights and legal remedies have just been redefined. This is educational content only, not legal advice. The source text I analyzed today is the official description of the Landor ruling. For any questions about how this ruling applies to a specific case, a specific prisoner, or a specific state's RLUIPA enforcement landscape, consult a qualified civil rights attorney who practices in this area.